Well, good morning, everybody. I'm Kevin Sutton from Miller Johnson, and this is our Legal Survival Guide Training 2021. Appreciate you joining us this morning. This event kind of marks a little bit of a historical date in that last year we did this training that fateful week in March, just a couple of days before everything got different. And things have certainly been different for about 14 months now. I hope everybody is doing well, staying safe. Obviously, a very interesting and challenging year for obvious reasons, but our need to refresh, renew, and re-examine the pieces of information that we have in place to make sure that our buildings are operating efficiently and consistent with legal requirements is always present. It's always present for us to do that. And so we do that today by talking about our legal survival guide. And got to say right from the jump here, our partners at MASSP have been wonderful to work with on this project. Obviously, the legal survival guide flows from us at Miller Johnson to them. And my understanding is that the good folks at MASSP have made the guide available to you. If you have any trouble accessing it, downloading it, printing a copy, whatever the case may be, that's MASSP's department now, but please direct any inquiries to them. If you have a lot of trouble, let me know, and we'll all connect with Wendy or somebody over there and get it squared away. I think everybody knows the drill now. We've been doing webinars now for 14 months, but in your control panel, you have a chat tab and you have a Q&A tab. The tab you want to use is Q&A. So if you have questions, please include them in the Q&A tab. And I'm really pleased to be joined this morning by my associate, Anya Lusk. Anya will be monitoring that Q&A tab, responding to some questions as they come in, or posing them here to the group for us to address collectively. And so questions in the Q&A tab. Because we're doing this virtually and not in person as we have in the past, we're doing it a little bit differently. As you're aware, we've broken this out into 2 days. I don't want to say to make it tolerable, but to take all the information we're going to give you and try to make it a little bit smaller bites with what we're going to go over. And so today, day one, you primarily get me. Tomorrow, you'll primarily get Anya, though we're both going to be present for both webinars. This morning, I'm going to talk about sort of what is this legal survival guide? You know, what it sounds like a fun name, but what is it? Where did it come from? How does all this stuff that we're talking about over the next couple of days fit together, and how do we utilize it as a school to make sure that we're doing what we need to do? And then we're really going to spend the bulk of our time going through the actual legal survival guide. Today, I'm going to talk about the student code of conduct, and then the 2 types of policies and administrative regulations that are outlined therein: student-centered policies and regs, and then general policies and regs. Tomorrow, Anya is going to cover really some very, very important and very interesting stuff. Annual notifications, which is something that we start thinking about this time of year to get ready to go out to our students and families in the summer at the beginning of next school year. And she's done all the legwork, taken this very complicated topic of notifications and made it really simple. And she'll go through all that. And then forms. For those of you that have reviewed the survival guide, we've got a bunch of forms in there that you can use. I'm just going to run through those tomorrow and explain to you why we have them, how they can be used, so on and so forth. And then we're going to it'll be final exam time, if you will, tomorrow after Anya talks about notifications and forms. And we're going to go through a bunch of different scenarios, hopefully applying everything that you've learned or everything that we've talked about over the course of our 2 days together, and really look at practical, real world issues, things that come up in buildings all the time, and how to navigate them. And I think that's very, very important, because while we'll spend a lot of time talking about policy and regulations and code language, we have to be mindful that these things aren't in a vacuum, right? It's great to have a perfectly worded policy or a great student code provision, but this stuff happens in the real world. It doesn't happen in a vacuum. And so looking at the practical application of these things, we think is very, very important, and excited to have Anya do that work tomorrow. And so we start, as I start sort of every year, of talking about, what is this legal survival guide? Again, very catchy title, patent pending, that we're very proud of, because it truly is, I think, what it sounds like. We believe that it is a resource that allows school administrators to survive from a legal perspective, everything that they need to do to ensure that their building is operating, and to a great extent, the district is operating in a manner that is legally compliant, and you're not tripping up on any of the roadblocks, potholes, or pitfalls that might be out there. This all starts, for those of you who've been around the block a few times, MASSP used to have something called a model student handbook. And the model handbook, I told Wendy very lovingly, was not really a handbook. It was a guide, and it had a bunch of different stuff in it. Some of it was code, some of it was policy, but it wasn't really a handbook, even though that's what they called it. Wendy came to us a couple of years ago and said, hey, look, it's time to redo this. It's time to maybe get more structure. And out of it came this legal survival guide. And so we're going to go through, again, in very detailed fashion, everything that's in there, but how to use it. Really, what is it? And I don't want to overuse the word resource, but it really is intended to be a resource. Do I want to say that it's the Bible, or it's definitive on everything you have to do? No, because one thing that we're mindful of is that every district is different. Every district has its own, and every building has its own local specific nuances. Certainly, there are a number of things that tie every public school and public school district in the state of Michigan. But to suggest that they're all the same is absurd. Livonia is different than Linden, is different than Lansing, is different than Ludington. Yes, I just thought of those 4 L's right there in that moment. But, so to say that they all should be the same and everybody should have the same language would be absurd. But I think what we want to do is know what is expected of us from a legal standpoint. And what are some things, if we've got issues, if we've got concerns that we want to try to address something, the legal survival guide will be a tremendous resource in looking at that and saying, okay, this is what the lawyers have drawn up. This is what they think is legally compliant. This is how they're approaching it. Maybe we can use some of this language. Maybe we can build off this language. Maybe we can take the language in its entirety and utilize it. And so it really is intended to be a resource. That book that you can go to if you're not sure about a topic, or you're not exactly clear on how to handle it, or how to draft something, or even where to begin, it's a great place to start, and really truly be a great sort of desk reference for you on all the various issues that arise in the building. And so, okay, great. Resources are good. Y'all have gotten a lot of resources in the last 14 months. Everybody's resourcing you to death, whether it's DHHS orders or stuff from the MDE, or, Google Classroom, or whatever. Kev, thanks for one more resource, but really practically, how is this going to work, and why is it important for me to sit through this training and read through this manual? And what I want to really focus on, and what I think the key to this is consistency. Okay. One of the things that we see, and I promise I won't wax prophetic here for too long, but one of the things that we very often see when we work with a school district is that there is a total lack of consistency between the student code of conduct, policies, regulations, notifications. Everybody sort of operated and drafted these things in a silo, right? Very often the code of conduct might be drafted by a building administrator or a group of teachers. I'm sure they intended well. I'm sure they did the best they could do, but they were only looking at the student code of conduct. Policy is very often drafted by your Board of Education, right? Maybe it's a board subcommittee, maybe it's a member of the board, maybe they have a policy service like Neola who's feeding them, dozens and dozens and dozens of pages of policy, but they're off doing what they think is best and what makes sense for the district, and they're adopting policy. In another room, the central office administration is often working on these administrative regulations or administrative guidelines, which of course implement board policy, give operational effect to the board policies. And they're in a room trying to do the best they can do and operating in good faith, but they're operating in their own silo. And so at the end of the day, what you get in most organizations is all these documents that are governing how we're supposed to do stuff. And there's not a lot of cohesion. There's not a lot of comparing. There's not a lot of alignment, if you will. They're just sort of created on their own. And standing alone, they look okay. But if I'm a parent, if I'm a student, maybe even if I'm a staff member, and I'm trying to make sure that I'm doing things the right way, then I'm operating consistent with the district's expectations, and I'm bouncing around and I'm getting a different answer depending on what document I'm looking at, which was drafted through the eyes of the person who was crafting that document, I might not have that consistency. I might not have that cohesion, and that can lead to problems. I can tell you that in many years of handling student disciplinary hearings and whatnot, I've had the situations where the district says, well, here, we've got the student code of conduct language. It says this, and this student violated it. And the parent will say, well, yeah, but your board policy says this, and it's different. They're not the same. There's inconsistency there. And so we don't want that. And so our idea here is to, when I say survival guide, is to give you all of these pieces, give you code language, give you policy, give you regulation, give you notifications and forms, which we have made sure are perfectly aligned. And there is consistency, and it's not this, the right hand doesn't know what the left hand is doing. We've tried to keep very intentionally to keep it aligned and keep it consistent. For those of you who maybe remember the Model Student Handbook, really loved it perhaps, and it was a good document, we've actually included in the Legal Survival Guide a model table of contents that kind of serves as a crosswalk. So you can kind of look at maybe what was there before, where you might find that concept in the new Legal Survival Guide, and an example of the type of things from a table of contents perspective that districts have. And so we think it's a really good thing. We think it's a really good approach to do it this way. Wendy and the team at MASSP have agreed so far, and hopefully after you get into it, you will agree as well. So ultimately, as I sort of suggest, what are we really talking about here? We're really talking about district governance. That's what this is. These documents, these things, policies, regs, codes, notifications, this is what governs how we operate. It's what governs the administration of our district, our students, and our parents to a great extent. And that's why we want to be really, really deliberate about making sure that this interplay between the documents is consistent. That we've got this stuff taken care of and it's in lockstep and we're not bouncing all over the place, right? And so I'm going to talk about what the reality looks like, one of two situations that most districts face, and how do we navigate those situations as they arise. So current status version number 1, you have a fantastic manageable policy manual and related documents. Everything is updated with regularity. It's easy to follow. You've got clear direction on what to do. Parents and students understand it. Your entire administrative team knows exactly what to do. The documents all integrate seamlessly and everything is sort of perfect. As the tones probably suggest, that's a bit of a utopian vision, and very, very few schools or districts fall into this category where everything is lined up. Got some that do a good job of updating, but maybe the consistency isn't there. I got some that maybe are consistent, but they don't update it very often. And so, this is very daunting, right? To think, well, Kev, look, you talk about utopia. What world do we have time to sit down and go over the code and go over the regs and go over policy and get all this stuff aligned? I get it. There's not enough hours in the day to do all these things, but that's why we try to give this resource to make it a little bit easier. But for the districts, maybe the very few, the rare few, and there might be a few of you out there that fall into this category, there are some key questions that have to get asked of how did you get there? Organizationally, how did you approach this? What do you need to do to keep it there? So if it's great today, what do you need to do to make sure that it continues to be great? Because one thing that is inevitable is change. Thanos was inevitable as well, but that's a whole nother story. Things change over time. Obviously, in a pandemic, things change. We get new orders out of Lansing every couple of weeks, and that certainly has us on our toes. And then I ask, is your manual and all these documents really fantastic, or could it be better? Are there ways that we can improve it? And so that is sort of scenario number 1. And again, doesn't apply to many districts or many schools. What most people are is version number 2. You have a bloated mess of policy manuals and related documents. Everything is kind of convoluted, very difficult to follow, very difficult to understand. And what we see in most districts is that this lack of alignment, this lack of consistency creates a lot of practical day-to-day challenges, particularly at the building level, right? It's great to write policies that have the word shall and must and all that good stuff. But what happens from a practical day-to-day point in the building? Okay, we get handcuffed to a certain extent in being able to do things, right? Because remember, policies were drafted by the board, maybe sitting in a room thinking that not that it sounded good. I'm sure, again, it was done with good intentions, but not only that it sounded good, but that's their idea of how a building needs to operate. You as a building administrator probably have a slightly different idea than a board member of how a building needs to operate. Again, this situation, this paradigm applies to most people. And just like scenario 1 and scenario 2, there are key questions to ask. How did we get to this point? How do we fix it? And once we fix it, how do we keep it that way? And so again, assuming most people fall into category 2, that's why we draft the legal survival guide and draft it in a way to provide this alignment across the board. And so this sort of concept of making it all work, right? Getting it all to come together and making it all work. The documents, again, I'm sort of until I'm blue in the face. The documents have to work with one another. The documents have to provide flexibility as needed. Yes, there are times where we need concrete direction, but generally we really espouse from a policy drafting standpoint, from a student code standpoint, that we've got flexibility. Because one thing that I know and that we know as a team in working with administrators around the state for a very long time is there are times you really love the concrete, but there are times you'd love the latitude to be able to address a situation in a way that you think is appropriate. And if you've been handcuffed by policy language or code language or regulation language, makes it really, really difficult to do. And when we come in and we start working with districts on policy, code, et cetera, what we see in those struggling districts, again, lack of cohesion. We very often see the board over legislating. And I don't know if we have any board members on here, and I want to be clear, I'm not trying to disparage our board members. My dad was a Board of Education member growing up. I know they are all very well-intentioned and they're doing their best. But again, oftentimes they're drafting policy from the perspective of someone who's not spending every day in the school district. They're drafting it as a board member. We often see a lot of administrative regulations that are ineffective or don't reflect the day-to-day realities of what's going on in the building. We also see a lot of student codes that are crafted in a vacuum, as I've talked about, that don't really apply. It sounds good, sort of very noble language about behavior, but doesn't exactly reflect the day-to-day reality of what we're doing. So how do we make it happen? Yes, there are policy services out there that can help. People call legal counsel to figure these things out. A lot of hours invested by the leadership team, but our hope is that there's another bullet on here, and it's the legal survival guide that helps you get all these things squared away and in alignment. The last thing I will say about this before we get to the guts is this concept. It's very easy to sit in a webinar like this and hear what we've got to say. Okay, legal survival guide, we've got it. It's a great resource, et cetera, et cetera. Love it, okay? There really is some other legwork very often to be done when you finish the webinars and you've had a chance to review the guide and you get back into your building. And that is maybe stoking up a larger conversation with the powers that be within the district. And if there are superintendents on this call, then you'll hear me in what I'm saying. You know, it's one thing for a building administrator to go and look and say, yeah, no, we want to make this tweak, this tweak, this tweak. And for central office to say, okay, yeah, that sounds great. But what is the larger implication for policy? What is the larger implication for our administrative regulations? And let's use this as an opportunity, not only to get our documents right? So for the things that we're sending students and, the application of our day-to-day situations and handling them appropriately, but let's use this as an opportunity to get stuff organized, to get stuff cohesive, to get stuff aligned. And let's think about the concept of having a larger call or a bigger mission than just updating the code. We're just updating the reg. Let's think about it in terms of an organizational opportunity to get this stuff perfectly parallel, perfectly aligned, and seamlessly working together. And I know that sounds daunting, right? Particularly at the end of the school year, particularly in a global pandemic. And I know everybody's burned out, but maybe good work for the summer when we sit down and we're trying to make sure that's there. So I offer that before we get into the guts, just to think about that in terms of an opportunity here and how we can really cohesively and cogently have everything aligned so we can move forward in a productive way. So the guide, for those of you that haven't seen the contents yet, this is what we have. We have it broken out into 6 sections. The Model Student Code of Conduct, number 1, annual notifications 2, Model Student Policies and ARs, Model General Policies and ARs, forms, and then that model table of contents for a student handbook that I talked about before. We're going to go this morning into sections 1, 3, and 4. And I'm going to mention it now just in case I forget. Kevin, what's the difference between model student policies and model general policies? I don't want to say a distinction without a difference. They're all policies and administrative regulations. But what we talk about in the student policies, the section 3.0, are policies that would be adopted by the board and related regulations that are really student focused. I understand that as a school system, we're always student focused, and all of this is about delivering education and curriculum to students. But those policies in section 3 are particularly student focused. The policies in section 4 are more district-wide operational stuff, as you'll see. They're not so targeted at specific student behavior, student issues, just more general district operational stuff, which, yes, of course, impacts students, but we've broken it out in that way to kind of make draw a distinction between the two. So with that introduction, let's jump over to our legal survival guide. Let's actually look at it. And if Kevin can pull this off correctly without screwing anything up. Okay, there, good. I see green over there, so that means I did it right. So this is our 2021 version of the Legal Survival Guide. I think we went with a very nice autumn color this year. Nice little burnt orange that we went with. And so when you get the guide, this is what you'll see, 87 pages. And hopefully this is big enough for everybody to see. Within our bookmarks, you've got everything navigated in terms of all the sections that are called out in each of those that we just talked about. And again, Anya's going to go through the notifications and forms tomorrow. So for our purposes, we're going to start with the Model Student Code of Conduct this time. And so I like to make sure we get a good view of the whole thing. And I'm going to read that little blurb, a little preamble that you see there on the screen. This Model Student Code of Conduct contains all of the materials typically found in student codes of conduct and is intended to address student expectations, student behavior, and student discipline. Ensure your schools or district practices align with the information contained herein before including any or all portions of this Model Student Code of Conduct in your student code of conduct. And so I won't say that, attorneys love disclaimers, but that's a little bit of a disclaimer, and it gives us some insight into what exactly we are talking about. Before I launch into this, I want to just give a brief comment about student codes of conduct, okay? Because this is something that has evolved, particularly in the last couple of years. For many, many years before the last few, we really leaned on student codes of conduct. I said, man, it's great when you're disciplining students and you've got upset parents. Why did my little Johnny get 5 days? And we would say, well, look, the student code of conduct says that for the offense Johnny committed, he could get 5 to 8 days. You should be very thankful that I gave 5. But our student code of conduct is very prescriptive. If my hands are tied, he committed the offense, you serve the crime, you've got to serve the time, or you do the crime, you've got to serve the time. And that's very much how we approached and utilized the student code of conduct. It was a tremendous resource, not only to justify our decisions, but to rebuff angry moms and dads about what we had done. That has changed, right? With the introduction of the 7 factors and the rebuttable presumption and all that good stuff, which, side note, I've always thought was interesting that we needed to be given 7 factors. Of course, the 7 factors are very likely the things that you as an educator always thought about before you disciplined a student anyways. But Lansing now has given us the very prescriptive factors that we've got to go through before making a disciplinary decision. And again, this rebuttable presumption against long-term suspensions and expulsions. And so really, what has student discipline become? Student discipline has become a case-by-case, very factually specific situation in which everything that happens needs to be viewed individually, needs to be viewed on its own merits, needs to be reflected against the 7 factors, and we make specific decisions about what needs to happen in that instance. So the natural outgrowth of that is that our old student codes of conduct that were very prescriptive, right? If you do X, you get 5 to 8 days. You do Y, you get 1 to 3 days. You do Z, you get 7 to 10 days. We can't have that anymore. The days of the prescriptive student code of conduct are gone, thanks to the 7 factors, 1310D, and the recent legislative changes that we got out of Lansing that relate to student discipline. And so if you still have a prescriptive student code of conduct that prescribes a certain number of days for an offense, I'm going to tell you that that probably doesn't pass legal muster. That's something that you're going to want to look at and address because you very likely have an issue there. That would probably run afoul if somebody legally challenged it of 1310D because it doesn't look at student discipline in an individualized case-by-case way, reflecting on the 7 factors. And so that's a big change. That's something that has changed quite substantially and quite dramatically in the last couple of years, and it's had a natural impact on our student codes of conduct. So be mindful of that. So with that being said, let's get into it here. And I'm definitely going to need to make this text a little bit bigger for you and for me. And what I'm going to do is I'm not going to go through and read every single section. What I'm going to do for this section, as well as the policy sections, is kind of scroll through and point out some things that we are seeing. Sort of the story behind the story, if you will, or things that we see coming up as common problems, common issues in the school districts that we represent, the 100+ districts around the state that we work with, kind of things that we see. I'll leave it to you to read it on your own, but I want to pull out some things that I think are important. We always have a very general introduction, which I think is always a good thing to have in a student code of conduct or any sort of governance document that maybe serves as a little bit of a catch-all. Note here that in ours, I'll make this one more click bigger. How about that? All students and parents are expected to sign and return a copy of the attached student code of conduct acknowledgement of receipt. And many of you probably have that practice of getting a sign off and having it sent back. I think it's really, really important. One of the things that happens, and I mentioned before that I do a lot of student disciplinary hearings, even still in a pandemic environment, yes. We get students and parents that come into these disciplinary hearings and say, well, we had no idea. We had no idea that that was prohibited. We had no idea that that was a requirement, et cetera, et cetera. So you can't waive the student code in our face. Well, we then pull out the acknowledgement form that says, I've received the student handbook. I acknowledge that I'm bound by its contents, et cetera, et cetera. And that argument gets defeated pretty quickly. We don't do it simply to defeat students and be in a position to be able to suspend or expel them, but it's important that students acknowledge receipt. But that's why we do that acknowledgement. So parents and students know that they've got it. They know what the rights are articulated in there, and there's no debate about it later on. Interscholastic or extracurricular activities. We've had a lot about this recently in terms of a student's right to participate. We certainly have had a number of issues this year in the COVID context when people have been taken out of competition because of close contact quarantining and whatnot. We'll set all that stuff to the side because I am hopeful that we won't have to deal with that next year when we get into the sports season. But one thing that comes up very often from parents is their student having a right to participate in athletics, a right to be on the football field on Saturday night. And if you don't let him, you're taking away his due process rights to be the quarterback of the football team. I will tell you, and again, speaking from a very sort of 30,000-foot perspective, students don't have a right. They don't have a constitutionally protected right, a due process right to be on the football field or to be on the ice rink or to be playing volleyball. They have a constitutionally protected right to be in school. That's what they have a right to do. They don't have a constitutionally protected right to participate in athletics. Does that mean that you should be removing kids from athletics left and right? Of course not. And of course, there's some legal nuance to that. But generally speaking, when you hear a mom and dad say, my child has a right to sports, the answer is, no, I'm sorry, they do not. They do not. Transportation, something that comes up from time to time, usually in the context of staff members driving students and then something happening. That wouldn't necessarily be addressed in the student code of conduct, but I think I will talk about that in policy. Student dress and appearance, I think an interesting topic, and we've got some model language there that I think is pretty straightforward. One of the things that we've seen in the last couple of years is a move to make dress code language a little more gender neutral. We could talk extensively on issues related to LGBTQ students and sort of the shifting legal landscape that surrounds them. But one of the small things we've seen districts doing is making a change to these. Instead of saying girls' dresses must be X and boys' suits must be Y, just talking about the clothing itself as opposed to the gender of the individual that is wearing those items. So something to think about there, gender neutrality in your student dress code and related materials. Police act investigations and arrests, pretty straightforward here. Search and seizure, again, pretty straightforward in terms of the language that is there. You know, one of the things that comes up very often in the search and seizure context is students claiming privacy. They have privacy. That my locker is my private property, et cetera, et cetera. Of course, it's not. The lockers are our property, and we can search them whenever we want. Not to get too far afield, but a little bit of context on searches. Because these things come up a lot. You know, we want to search a student backpack. We want to, you know, maybe the drug sniffing dog is in and hits on a kid, et cetera, et cetera. This goes back to a case called TLO versus New Jersey, Supreme Court case, and boiling down a lot of legalese. What the Supreme Court gave us was a two-step test when we're going to do a search. And when you guys call us, even today, we look at TLO and those two steps and think about them. And the first step is, do we have reason to believe the student violated the student code of conduct? That's the first step you've got to clear. Do you have a reason to believe something's wrong? Do you have a reason to believe this person might be the reason that something happened? And then if you have that, then secondly, do you have a reason to believe that the area you want to search might produce evidence of the violation of the student code? So what does that mean, practically speaking? You know, I'm walking down the hall, you know, I'm a bad kid, I'm a discipline problem, I've got a history of being a real jerk, and you decide you just want to give me a hard time that day, so you stop me and ask me to empty my pockets, empty my backpack. Is that going to be okay? Well, no, because you didn't have reason to believe that you didn't have reason to suspect that I violated the student code of conduct. You just stopped me because I'm generally a jerk, and you thought maybe I might have something in my pockets. Different story. You know, call goes out over the radio and they say, hey, we have reason to believe that a bald, bearded, devilishly handsome guy was just utilizing drugs in the bathroom. If you see this person, let us know. And all of a sudden you see me strolling down the hallway. Well, now you might have reason to suspect that I violated the student code of conduct. Now, they said drugs. So could you ask me to empty my pockets? Yeah, I might have drugs in my pockets. And so obviously a very fact-specific inquiry that we're doing in situations of search. But I like to at least throw that out so you're aware of it, that those two prongs from TLO. I mentioned the drug sniffing dogs. What does the drug sniffing dog give us, right? Gives us reason to suspect the student violated the student code of conduct because the dog smells drugs. Where do they smell the drugs? In the backpack. Do we have reason to believe that where we might search, that where we're going to search might produce evidence of the violation? Yes, because the drug sniffing dog is barking, right? That's all about TLO and that two-step inquiry. So a little bit of insight there on that topic and how we think about student search and seizure. Student bullying and cyberbullying, obviously a major issue, an issue that has gotten a ton of attention here in recent years, and rightfully so. You know, we used to think that bullying going on in school was the big problem, and it still is a problem, but certainly cyberbullying is right there as problem 1A with respect to student interaction. And so a lot of the language you see here in this student code 1.7 comes directly from the law. These are things that they talk about in the law about wanting to list. And you'll notice it's a really, really long provision of the student code. But there's all of these steps. This is Matt Safe School Law that was passed back in 2011, I think, that very much laid out specific definitions, specific things that we needed to include. Complaint procedure. You see here in the middle, we have a tie into district policy. So there's a reference to that in the code, the steps we would take for investigation, having a decision found, et cetera, et cetera. Now you might look at that and say, holy cow, Kevin, compared to everything else, that seems really, really long. It is long. And that's in part because of the law. And frankly, it's in part because it's one of the most prevalent things that we deal with. And I'm sure you're dealing with at the building level. You know, I hate to say, but if I had $1 for every cyberbullying or student bullying question we get in a given year, it would be a really good year financially, because we get a lot of those things. And so we've been detailed not only because the law requires it, but because you're going to deal with a lot of it. And so getting that information out in front of students and parents early on to let them know the seriousness with which we address those concerns and the processes and protocols that are there, I think is really, really important. Introduction to disciplinary actions and prohibited acts. And so this section is really an outgrowth of what I was talking about and the change in the law and moving away from this idea of prescriptive student code, right? commit offense X, you get 1 to 3. Offense Y, 5 to 7, et cetera, et cetera. We give a general statement, as we do very often, about establishing rules for governing obvious types of student misconduct. It's not an all-inclusive list. There are certainly things that maybe a kid would do that we would never think of that we haven't included on the list. And so it gives us that flexibility as administrators to address behavior that maybe isn't specifically called out. It's funny, we just had a conversation with the district the other day, and they wanted something very, very prescriptive about something that I thought was really quite obviously bad, sort of common sense bad behavior. And they really, really wanted to put language in there. And I said, well, look, the danger, we can do that, but the danger is this. When we start calling out obviously inappropriate behavior and saying it's inappropriate, there becomes a danger that someone might say, well, behaviors that aren't specifically called out, even if obviously inappropriate, must be permitted then because you've called out these other obviously inappropriate behaviors. That, of course, is a flawed argument. I've seen it made in a number of student disciplinary hearings. The idea of this language in the introduction of 1.8 is to give us the flexibility that we need to address things even that aren't specifically listed. This section about range of discipline, and this is what I was getting into when I was talking about we can't have X and Y anymore. And you'll see here that I have highlighted the phrase, the discipline for violating some prohibited acts ranges from administrative intervention to expulsion. So basically the entire range of possibilities. And really, I think if we're being honest and we're trying to faithfully comply with the law, every situation we come to, except those that are specifically called out by the legislature as mandatory expulsion offenses, needs to be looked at as having the full range of possibilities. Because again, we need to review every situation individually. We need to consider the 7 factors, consider the rebuttable presumption, all that good stuff, and then make a decision. And so really, every time we come to a situation, it should be the full spectrum of possibilities, even though naturally some things are going to require less and some things are going to require more. I think faithfully, if we're operating faithfully consistent with the new law, we need to look at having that full range of access to outcomes. And that's why we've got that language outlined specifically in the code in terms of range of outcome. I think very importantly too here is this list at the top of the next page that talks about are applicable when a student, okay? And I think we see this happen a lot, okay? Parents, students think that the only thing they can get in trouble for are things that happen at school during the school day. That's it, 1st through 6th hour. If it happens outside 1st through 6th hour, I'm okay and you can't get me, right? That's not true because a lot of activities have a nexus to the school environment. A lot of activities have that nexus or causal connection to school, the school day, school activities, school events, school-sponsored events. We know that when we take students on a field trip, which is something that, again, hopefully we can do again someday, that's an extension of the classroom. The expectations that exist in the building exist when we're at Greenfield Village, okay? This language is intended to put families on notice, to put students on notice that it's not just 1st through 6th hours, that it's all of these other things that touch and have this nexus to the school day, that if you engage in behavior that is prohibited, there can be consequences. And so, a student code, yes, is about articulating expectations. It's also about giving notice to a great extent. And that's why we have the parents and the students sign the acknowledgement, right? That you've been given notice, you've been warned, so to speak. And that's exactly what this is letting them know that it's not a narrow sliver of things, it's a big piece of pie in terms of the areas where your behavior can be addressed by the school. So very important there. You've heard me use the phrase rebuttable presumption already, and this section in 1.9, again, giving notice to families and making it really clear from a disciplinary standpoint what we're talking about. We've got our factors listed there, our 7 factors, and again, this language of rebuttable presumption. I know there's been a lot of PD on these things, but I want to take just 1 second to talk about this rebuttable presumption because it is a phrase that unquestionably was crafted by a lawyer, all right? And so what is a rebuttable presumption? What does that mean? If this is review for many of you, I apologize, but I do get the question a lot. What the legislature was saying is, we want a presumption that you won't long-term suspend or expel kids. So anything 11 days or more, okay? There is a presumption that you shouldn't do it. We don't want it to happen. There's a lot of policy reasons why they reached that conclusion. I won't get into all that here, but they have stated in the law this presumption that you not do that. That presumption can be rebutted, defeated, knocked down, beat up, whatever, by showing, going through the 7 factors and showing that there are circumstances that warrant long-term suspension or expulsion. So it does not mean that you can't long-term suspend or expel kids. Of course, you can still long-term suspend and expel kids. But what the legislature is telling us is we really, 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 really don't want you to do it unless you got a really, really, really good reason to do it. So it's this presumption that you can't do it that can be rebutted. Okay, and that's what a rebuttable presumption is. And I will tell you, it took me 3 semesters of law school to figure out what rebuttable presumption meant. That's what it means, because nobody ever explained it to me like that. But that's what this whole deal is about. And so, you know, why? Well, because we were having a lot of disparate impacts, disparate outcomes with students, and we were moving students from school way too much. Not because we were malicious, but because that's the way the system was set up. And they are swinging the pendulum back the other way now and trying to get us to keep kids in school. Consistent with that is restorative practices. And I'm not going to talk about restorative practices here because I'm sure everybody on this call is an expert tenfold over what I am in restorative practices. But that idea of restorative practices is consistent with the rebuttable presumption and consistent with the overall attempt to keep kids in school. What we see statistically when we're suspending kids left and right, we've got mandatory expulsions, 3 strikes and you're out, 0 tolerance, all this stuff. At the end of the day, statistically, who's being harmed the most? The kids who can least afford to be out of school, the at-risk kids, right? Minority populations, marginalized populations, kids who are already at risk. Those are the kids who statistically are being impacted by all of these suspensions and expulsions overwhelmingly. And so we're trying to swing the pendulum back and stop that behavior. And so ultimately what they're telling us is we're going to try to keep the kids in. That's what we're trying to do here. That's why we've got rebuttable presumption. That's why we've got restorative practices to try to find outcomes other than you're out of school for a certain number of days. Okay, that's what that is all about. And that's what we've tried to memorialize here to give notice to moms and dads so they know what's going on. All right. Definitions of discipline. We explain what administrative intervention, suspensions, and expulsions are. I'm going to try to jump over snap suspension, but somebody will call me out on it, so I will stop there. There is a provision in the law that allows for snap suspensions. I will tell you that in every district we work with, central office is very leery of snap suspensions and doesn't really want teachers engaging in it. We have included this language on snap suspension simply because it is in the law. It is a resource that is there, but that's something that you certainly want to consult with your central office team before you plug into your student code of conduct. We don't want any teachers reading this and saying, hey, wow, cool, I can do that, and going rogue, so to speak. There is some again, a legal authority for them to do it, but that's why we've included a snap suspension in there. But the key definitions are administrative intervention, suspension, and expulsion. The balance of the model code here is prohibited acts, right? And so this is sort of the laundry list that most of you see, most of you have in your student codes of conduct, where we try to call out the things that are prevalent, the things that are happening that we want to make sure are strictly prohibited. Again, it's not an all-inclusive list. We've already given that caveat. And so just scrolling through the list, I think we've done it alphabetically to make it easy. Alcohol, marijuana, and controlled substances. Get a lot of questions about marijuana. Well, Kevin, marijuana is legal now in Michigan, isn't it? Yes, it is in some instances. It's also still prohibited federally. Let me break the news on that. Marijuana is still illegal federally for now. That might change. It certainly seems like the winds of change are there to make that happen, but still prohibited federally. We still have federal drug-free school zones, et cetera, et cetera. And even in Michigan, 17 and 18-year-olds can't be smoking marijuana and they can't be high at school. And so the legalization of marijuana in Michigan doesn't make a whole lot of difference. Yes, there are very highly nuanced situations of medical marijuana cards and how those might apply. Those are things that you call legal counsel for to try to figure out how to navigate. Haven't had that issue with a student, it's usually been employees or applicants for employment, and we deal with HR on those things. But know that the recent change to Michigan law is not a free pass for everybody to light up at 420 on school grounds. It doesn't work that way. Arson prohibited by law, bullying and hazing, right? So this obviously, again, is another opportunity for us to tie back into board policy. Every district is going to have a board policy that specifically addresses bullying because you're required to by the law. And so another opportunity here, we've already covered it in one section of the student code. We reference it again here in our list of prohibited acts with a tie back in to our board policy. Coercion, copyrighted material, criminal acts, criminal sexual conduct. I do want to stop here on criminal sexual conduct and say, we're going to talk a little bit about Title IX when we move into the policies and regulations. But if there is an area that we all need to be hyper vigilant and hyper sensitive to right now, it is criminal sexual conduct. It is allegations of sexual harassment. It is situations involving contact, unwanted contact, physical contact between parties, so on and so forth. I promise this is not a sociology speech. It is not a political speech. But what I will tell you is this. We have an overwhelming movement going on, maybe an awareness, maybe an awakening, if you will, in this country as it relates to these topics. There's movements going on with awareness on other topics too. But as it relates to criminal sexual conduct, sexual harassment, sexual discrimination, sexual violence, etc., we are dealing with, on a daily basis, a tsunami of complaints. A tsunami of Title IX complaints, and making sure we're navigating compliance on that front. We're having situations where prosecutors are charging CSC for things that happened by one student against another. And we have to be hyper vigilant. There are provisions now in Michigan law adopted by our legislature in the wake of the Larry Nassar atrocities that talk about mandatory expulsion for students who are adjudicated to have committed CSC. All right. Now, maybe that seems like common sense to everybody, but it's something now that is required. And so I don't need you to memorize the statute. I don't need you to remember, take, copious notes on everything I'm saying. But what I'm telling you is you should have a little voice in your head. And if you have an issue that has to do with CSC, sexual contact, allegations of sexual harassment, I want, you don't need to remember me. Just remember a little voice screaming in your head. We might have an issue here. Is this Title IX? Do we have a Title IX problem? Do we have a CSC problem? And ask the question. Ask the question of your Title IX coordinator. Ask the question of your central office folks. Call legal counsel and ask the question, because it is a tidal wave right now of claims, of lawsuits, and issues of gross noncompliance by a lot of school districts. And so, again, Title IX training is an issue for another day. We will talk a little bit about it from a policy and regulation standpoint in the next hour. But that little voice in your head, please, because it is so important, and there are requirements legally that we've got to navigate. And if we don't do it, we will find ourselves in trouble. 9, discriminatory harassment. Similar discriminatory harassment, not just on the basis of sex, but all those other categories of prohibited discrimination, race, color, national origin, religion, etc. Quick pause here to say sex. We need to interpret sex to include gender identity, gender expression, sexual orientation, etc. Okay. There might be some folks on this call who follow this topic and say, well, wait a sec, Kevin. The Elliott Larson Civil Rights Act in Michigan doesn't list gender identity, gender expression, or sexual orientation. So why would you say that would be included in prohibited discrimination on the basis of sex? I say that because our U.S. Supreme Court had a case last summer called Bostock, which was an employment case, but they said that the definition of on the basis of sex under Title VII, which isn't Title IX, but under Title VII, included gender identity, gender expression, sexual orientation. That's the way this is going. That is the trend. And if I had more time, I'd wax prophetic on it, but that's the way this is going. And so I think when we're thinking about what is appropriate dynamics between students, I don't think we should be ruling out gender identity, gender expression, set what I call sex stereotyping, discrimination on the basis of sexual orientation. These are categories that courts around this country are finding are protected, even if they're not specifically listed in the Elliott-Larsen Civil Rights Act. Under Michigan law, federal courts are finding it left and right. And we certainly know that the U.S. Department of Education Office for Civil Rights, which is now under the direction of the Biden administration, is going to aggressively enforce against schools any discrimination that they believe is based on gender identity, gender expression, transgender status. And so we want to be vigilant about that. We want to be mindful of that. All right. I know I'm throwing a lot at you, and there's a couple of different topics in there: Title IX, LGBTQ, OCR. But I just want to make you mindful of those things. So again, little voice in your head if you have those situations, and you can respond appropriately and correctly. Some general ones here: disruption in school, a lot of latitude there, damage of property, dangerous weapons, inappropriate dress, drugs, narcotics, etc. Electronic communication devices and laser pointers. Yes, people still have laser pointers. And yes, people still use them. We still get calls on that stuff, so we've included it here. This is model language that we have here. Some districts have tailored their electronic communication devices very specifically depending on the type of device. Some have gone more robust, some have gone more Spartan in their approach to these things. Again, this is intended to be model language to give you a jumping off point to calibrate consistent with what your expectations are as a building and as a district. Another in the F's here, we got a laundry list of things that would make sense in terms of having: failure, false, falsification, fighting, fireworks, chemical substances, gang insignia and activity. I'm happy to report that at least in my corner of the world, in the context that I'm having, we don't seem to have as many issues with this as we had many years ago. That's a good thing, and hopefully it stays that way, but we do have language in there to address it. Improper communications is one that we are going to number 24 a lot these days in terms of addressing student behavior that they're engaged in online. Of course, you all know everybody's just kidding. Everybody was just joking when they published a photo of themselves with an AR-15 saying, "Don't come to school tomorrow." They were just kidding. I hear that excuse a lot in student disciplinary hearings. And of course, whether they were kidding or not is not the point. It is an improper communication. And not only can we address that type of behavior under our student code, our local prosecutors have taken to addressing that type of behavior as well. Indecency, lookalike weapons, misconduct, personal protection devices, trespassing, loitering, scholastic dishonesty, which seems like an antiquated topic, but still happens, smoking and tobacco. And so somebody's, I'm sure, going to post a question and say, "Kevin, what about vaping? What about the evil vape?" We've included that language here. This includes e-cigarettes, vaporizers, or any other device that simulates smoking any type of product, whether it's named under that product name or descriptor. And so we've been inclusive there. If you wanted to call it smoking tobacco / vaporizers, you'd get no objection here. We could certainly do that. But we've tried to address that here in the Student Code of Conduct because I know it is something that is a big deal these days. Violations, so on and so forth, building rules, weapons and dangerous instruments, the things that you would expect to be in there. And so our laundry list, 35 items, again, not an all-inclusive list, but hopefully there's some things in there that maybe you haven't thought about or some language that will allow you to build out maybe areas that you think could be strengthened a little bit. Section 1.12 here lays out very specifically what due process looks like. And this is a topic that trips up a lot of districts, a lot of buildings in terms of due process. And again, I'll be brief from my legal review standpoint, but there was a case in the 1970s from our US Supreme Court called Goss versus Lopez. And what Goss versus Lopez focused on was this idea of due process, student due process, when they're going to be removed from school. And that's what, all these numbers, 10 days or fewer, 11 to 59 days, 60 days and more, all that good stuff. This is all built off the concepts that are articulated in Goss. And what Goss in essence says from a due process standpoint is, look, students have a constitutionally protected property interest to be in school, to get their education, right? To get their education from the state, public schools, et cetera, all right? They have a right to be there. If you're going to take away that right by suspending or expelling them, We think that there's got to be some due process. And due process, I've always thought is kind of a sort of a scary, intimidating, legal sounding phrase. Oh, due process. I have union people all the time that throw out due process, and attorneys call for students. And my student didn't get his due process. And it sounds good. It sounds like something we'd hear on Law and Order. But what is due process? Due process is pretty simple. It's an opportunity to know what the problem is. Somebody tells you what the charges are, what they think you did, and an opportunity to respond. You can respond to those things. That's it. That's all due process really is knowing what people think the problem is and being given a chance to respond to it. So what the Supreme Court is saying in Goss is if you're going to take away a kid's right to be in school, we think there's got to be some procedures with that. You just can't be like, don't come back, right? You got to give them some procedures. So they sort of draw this line at 10 days, okay? And this is Kevin's vernacular, sort of the less big deal and the bigger big deal, right? So the kind of minor stuff and the big stuff. That's how we sort of use the dividing line at 10 days, kind of what's below it and what's above it. And for the lesser stuff, right? The short-term stuff, 10 days or less, right? Very, very minimal stuff, right? Basically what I said, tell the kid what they did wrong, what you think they did wrong, give them a chance to respond. If you do that, yeah, you can give them less than 10 days. That's fine. They're not worried because you're not having a major impact on taking away their right to be in school. You're keeping them out less than 10 days. It's not a huge deal. It's not a major deprivation of their constitutionally protected property right. Stuff on the other side of 10 days, 11 days or more, yeah, that's kind of a bigger deal, right? That's a more significant deprivation of their constitutional right. And the Supreme Court said, you got to do a little bit more, right? That's where you're going to have probably a student disciplinary hearing. They're going to have a right to have an attorney. If they want to ask questions and see the evidence, they have a right to do that because you're going to keep them out of school for more than 10 days. That's a bigger deprivation of their constitutionally protected right. And so I'll stop there without getting too far into the weeds, but that's where all this comes from. That's why we hear 10 days, 10 days, 10 days. It's all about that idea of due process and what falls, is it a minor deal or a bigger deal? And then what sort of protections do we need to give the student as a result? And this section 1.12 is what's spelling that out, right? And thankfully, Michigan has piggybacked off that now and codified this. Short-term suspension is the minor stuff, right? 10 days or less. The longer term suspension is 11 days or more, really up to 59 days. And then expulsion is 60 days or more. And so we've laid all this out right in here and explained what the process is from a due process standpoint to make sure you don't get tripped up and explain what the steps are. We not only want to make sure that you're doing what you need to do from a due process standpoint, but that moms and dads know what the expectation is and they've got that notice. And that's why they receive this stuff up front and they acknowledge receipt of it. We've got a little, what I would call an attorney catch-all here about any inconsistency gets resolved as detailed therein. So maybe good language to plug in if you don't have something like that. Gives us a little bit of flexibility if we need it. So I'm going to pause there. And Anya, I guess I'll put you on the spot, maybe ask you to turn your mic on. Do we have any questions? Has anybody submitted any questions that we need to get cleared up on our student code of conduct stuff before we pivot and start talking about policy?
So I have a couple of questions I'm in the process of answering now, but for the most part, I think we're good.
Okay, well, hey, I love it when we get the first hour in and everything is crystal clear. Good stuff. Normally, I would say, hey, let's stretch our legs for a few minutes. And if we were up in Lansing at the M-Leg building, we would probably do that. But given the fact that we've constructed this into a 2-hour block, if you need to run to the restroom or get a new cup of coffee, go ahead and do that. But I'm going to plow ahead because I think we've got a lot still to cover, and I want to make sure that we leave time for questions. Don't mean to make you dizzy here for a second. I apologize. I'm just going to scroll down here to get to the policies, and we'll dive into those. And so again, remember, I've differentiated between student-focused policies and what I call general policies. Again, we have another little preamble here on the cover page. This is a collection of student-specific policies and administrative regulations. Policies should be adopted by the Board of Education. Pardon me, administrative regulations which give force and effect to policies adopted by the board should be agreed upon by the school district's administration team and be consistent with your school's or district's current practices. So a real quick comment on that. In some districts, the board also adopts administrative regulations. That is not the Miller-Johnson way. That is not what we necessarily recommend. And for our policy service and our policy clients, we recommend that administration adopt the administrative regulations on their own, subject to sharing them with the board so the board knows what's going on. That might be different in your district. All right. It might be that the board adopts all of these things. But when we talk about them as policy is adopted by the board. Regulations are crafted by the administrative team as sort of I look at it this way. Policy is the foundational principles on which the district is built. Okay, this is what we stand for as a school district. Those things should absolutely be adopted by the Board of Education. Those folks have been elected to represent the community, and they should absolutely be the ones who are stating this is what we stand for as a district and adopting that policy. The regulations are the day-to-day. They're the blocking and tackling, the X's and O's. And we operate under the belief that those things should be drafted by the administrative team, implemented by the administrative team, because they're the ones who've been tasked to run the district on a day-to-day basis. And so that's how we view them. You'll notice the reference to the different headings, blue and burgundy. And as we scroll into this, you're going to see this. And I'm just going to scroll down really quick to give you an example. We've got one here. We'll start with education records. Blue is the policy. Right? This is what would be adopted by the Board of Education, what would go into the policy manual, et cetera, et cetera. The regulation is in, I guess we're calling that burgundy, maroon, I don't know, burnt orange, whatever it is. Maybe if you're a Texas fan, it's burnt orange. And you'll notice here on the side, it's 3.1-AR, meaning administrative regulations. So that's the piece that we think the administrative team should put into place. And so for many of these, there's both a policy and a regulation. We give them side by side. Sometimes it's just a policy. Sometimes it's just a regulation. The idea is kind of where does it go and whose bucket does it fall into, right? At the end of the day, all of this is model language for you to use as you see fit, if appropriate. What you might notice is that our regulations tend to be longer than our policies, generally speaking. There are certainly some exceptions, but generally speaking, our regulations are going to be longer than our policies. Why is that? Well, because I think, again, policies are foundational principles. They state what we stand for. The how we do it really is the regulation. And oftentimes when I talk to our school policy clients, I'll use sort of a rudimentary example of, we want to have a drug-free school environment. That's a policy statement. That's a policy, right? Are we going to be involved in the DARE program? Are we going to have drug sniffing dogs? What day of the week is the drug sniffing dog going to come? Are we going to have our liaison officer educating students on drug awareness and all that other good stuff? That's all executing the general principle of drug-free school environment. That's all administrative regulation. And I like to talk about this, not only because it's in the guide, but I like to talk with this audience, which is very often building level administrators, because you should have a hand in drafting those. You should have a hand in drafting administrative regulations. Administrative regs or guidelines, some people call them administrative procedures. That is almost a how-to guide, a day-to-day guidebook of how you're supposed to do your job as an administrator. And so involving administration in the development of those things and allowing those folks, such as yourselves, to have a voice in the crafting of those things, I think is vitally important. If you don't do that and the board just goes and gives the X's and O's, that can create some problems. And so that's how we've set up these two policy sections: blue for policy, burnt orange or burgundy for AR, and that's why you'll see them side by side. We'll start with education records, and I won't say a lot here about this other than this is the FERPA stuff that we're talking about. You'll see this idea of directory information, and I just point out here, this question comes up a lot every year. We get a request and people want information, and can we give it? Can we not give it? What about FERPA? FERPA has this concept of directory information. And what directory information is information that's not protected by FERPA, that it can be released without FERPA consideration. And it's general stuff, right? Student name, address, telephone number, photograph, that kind of stuff. This list that I have here, that we have here, is not a required list. You can edit this list, or your board can edit this list, or your administrative team can edit this list as you see fit. The key is that students and families are made aware of what is on the list, right? That's part of the annual notifications. Anya will talk about that tomorrow, but you can tailor this list as you see appropriate as a school district. It's not to say that you got to have these 8 bullets, and many districts have lists that are shorter. Many districts have lists that are longer in terms of we can set what directory information is. We just have to make sure we give notice to our families. And as many of you know, families then have the opportunity to opt out. More on that coming from Anya tomorrow when she talks about notifications. But I like to point that out because we get a lot of questions on an annual basis about directory information. And so, here then we get down to the regulation about education records and student records. And you see, we have sort of more granular topics: creation and retention. What goes in a CA60? What do we do with the special services file? What about this directory information and access to records? And now there's going to be protocols in place for if a parent has a FERPA request or a parent wants to make a change to a record, so on and so forth. Because under FERPA, parents can amend education records. We put all this nuts and bolts, this blocking and tackling, again, if you'll excuse the analogy to sports, into the regulations, because that's the meat and potatoes. That's what we're doing on a daily basis. And so all of that is there for your review and adoption. Student activities, again, we're back to blue. So we're talking about policy, and we're thinking about what the board needs to articulate. And so you'll see these are all short and to the point. The superintendent, in consultation with the board and selected school personnel, will develop and administer a program of curricular and extracurricular student clubs and activities. You might look at that and say, wow, Kevin, that's pretty short. It is. But what more does the Board of Education really need to say? I mean, ultimately, if they've hired all of us to run the district, they're saying, go create a program. And that's what we should do, right? But from a policy standpoint, that's all the board really needs to say. And so we keep it pretty to the point. For those of you that might be in, and I don't want to pick on them, but they're the only other game in town, Neola districts, you'll say, man, our policies are like 14, 15 pages long every one we look at. Our manual's 1,000 pages long. It's just a different way of drafting. Okay, Neola sort of has the comfort in volume approach, and they want to give you all of the detail, all of the X's and O's, all of the blocking and tackling in a board policy. We don't do it that way. We break these things out and put them more appropriately, we think, in the bucket that they belong in. And we try to streamline this stuff from a policy perspective. Even when we get them in the right bucket, we try to talk about policies in a way that's really straightforward, no legalese, and kind of to the point. And again, that's just a difference in drafting methodology. It's not to say one is right or one is wrong. Of course, we think we're right. No, I'm kidding. It's just a difference in methodology. And so that's why we have what we have there. Again, AR that goes with student activities. So this would be the administrative regulation. And now we get into the stuff that we would need to get into, right? From an operational standpoint. Fundraising. Fundraising is a huge issue that comes up, right? What do we do with accounts? How do we keep accounting of the money that's coming in for these various extracurricular activities? There's something, if there's any finance folks on here, called GASB 84, which is something that the finance people sleep with under their pillow. We want to make sure that we're complying with that. So we've got a reference to that, so on and so forth. And so again, get you into the granular detail of what is going on here. Same thing, again, same paradigm when we talk about behavior. Blue means board policy. What does the board really need to say? They need to talk about things from a high level, from a 30,000-foot perspective, if you will. Attendance. We expect kids to be in school every day. Student appearance. We expect them to look appropriate. Student code of conduct. We've got one, and we expect you to follow it. If you don't, there are due process protocols, which we just reviewed in the student code of conduct, that allow us as a board and a school system to address the behaviors that come up. Remember, very early in this presentation, maybe seems like hours ago, it was only 60 minutes ago, I talked about cohesion and alignment. I talked about these documents not being crafted in a vacuum or in a silo, and that there needed to be interconnectedness. You start to see that now, right? We've got a student code of conduct where we've talked about due process, we've talked about discipline, we've talked about our expectations. Now that language is being mimicked, albeit shorter and more to the point in board policy, but it's being addressed. So no one's going to be able to throw the policy at us and say it looks different than the code. We want these things to match up, and that's what we start to see here, utilizing these different resources, is there being that alignment and that cohesion across the board. References in here to district maybe having an athletic or extracurricular code of conduct. Many districts have that as well. That's something that can certainly be integrated and referenced in board policy, as you see here, or it can be addressed in administrative regulation as well. You continue here with policy. Again, different subsects of board policy on different things that come up with students. Again, all short, sweet, and to the point, but the board having a statement. So what I would encourage you to do is scroll through these things. Does our board have something on this? Does our board want to have something on this? Would it help us as administrators if our board had something on this, and why? Again, model language. Great example here is personal electronic devices. You know, students are permitted to use electronic devices before and after the regular school day, during lunch, as directed by a teacher. Well, some of you might have policies that are more liberal than that. Some of you might have policies that are more conservative than that. Our idea is to try to give you a jumping off point if that's something that you have concerns about or something that you want to try to address. Okay, a really interesting one here. Again, we have this as we've got some boards that have adopted this policy. Food deliveries. We started thinking about this because we were getting a number of calls from school districts, high schools in particular, right before the pandemic hit, that kids were calling Grubhub and DoorDash and whatnot, and food was being delivered to the building. And it was becoming a real problem for the front office. And so addressing this behavior specifically in policy to prohibit it was something that a number of our school districts asked for. And so we developed this policy. Makes it really clear, can't do it. So if a student says, well, it doesn't say anywhere I can't do that. Actually, it does. It says it in board policy. Is that something that we could add to the student code of conduct? Of course it is. We could if we wanted to, but we thought having a little bit of policy language would be helpful. So something to think about. I'll tell you, we had a number of school districts said, no way, we don't want that. We don't want to give people even the idea that that's even a possibility of something they could do. And we haven't had an issue with it. But again, something to think about that maybe might be beneficial for you to have as a district. We switch over to burnt orange, and that means we're in the AR. So now we are applying, right? We're applying stuff. You'll say, man, Kev, that student bullying stuff looks very similar to what we saw in the student code. It is. It's very, very similar. Our administrative regulation matches up with the student code of conduct, having these things, the implementation piece, the definition piece, and all of the other steps on accountability, retaliation, and complaint procedure that you saw in the student code of conduct. Again, consistency, 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 and the various stakeholders, the various groups across the district acting in lockstep, acting in concert, and there being no gaps in our wall of defense, and having that consistency across the board. So this language very much parallels from an administrative regulation standpoint what you saw in the student code of conduct. So I won't read all of it, but I'll scroll through it. Athletic code of conduct, if we have that athletic code of conduct, good place to reference it here in the administrative regulations, and then another reference to staff suspensions. And I talked about that a little bit in the code. I won't cover it again. I apologize. It looks like there should be a line space between those two things, and for some reason we don't have it. So know that that's not one section, that's two sections. Apologize for the typographical and publishing error. Health and safety, blue means board, blue back to the Board of Education and policy. And what you'll see here is really straightforward things. And I'll jump to a couple that come out. Immunization is one that 2 years ago we were never worried about having too much about immunization. And now it's all anybody wants to talk about. Pretty straightforward from a policy statement. Same with medication, right? There are kids that need to have medications at school. We address that, but from a board standpoint, and what the policy needs to be, the policy is that the superintendent will develop regulations concerning student medications, and that the regulations will address the various aspects of that. That's all the board really needs to say from our perspective. We don't need the board getting into what cold storage we're going to use for student medications. They just need to say, come up with a plan to do it. One thing that's gotten a lot of attention in the last couple of years is seclusion and restraint, as many of you know. And there was a belief that everybody needed to have policy. I won't say a belief. There was a requirement that everybody needed to have a policy. The belief part came in that it needed to be this big, massive thing. It doesn't. From a policy standpoint, we think legally all you need to have is what it says right there. The board directs school district personnel and others to comply with Michigan law prohibiting seclusion and restraint, except in those emergency instances that are permitted. That's it from a policy standpoint. We believe that's all the board needs to say. If there needs to be more about it, we can put it into an administrative regulation, but in terms of a policy statement adopted by the Board of Education, it needs to be very short, sweet, and to the point. EpiPens, this is language that we're required by law to have a policy on, a board adopted policy. And so you see the language there, a little bit longer, not too long, but a little bit longer, and language that you have to have in your board policy manual. One thing that we have integrated with some of these things, there's been some back and forth lately about the Narcan. And the category is slipping my mind. Anya, if you remember it, jump in and call it. But the Narcan. Yes, opioid antagonist. Thank you. I appreciate it. Wednesday morning, that phrase was eluding me. Thank you. The opioid antagonist, Narcan, is mostly what people have. There was some back and forth in the legislature about if you're going to have these things, you have to have a policy. And then there was some backtracking from that. I would say ultimately, if you're using Narcan or other opioid antagonists, other brands of opioid antagonists, it's going to make sense to have something written down someplace, okay? Whether that's a board policy or you decide to include it in administrative regulations. If that's something that your high school or your middle school or any of the schools is stocking and using, that we want to have some language someplace about that. So we had, for some districts, historically included it in the EpiPen policy, had some language on opioid antagonist, something to have there if you're using that. I think it's wise to have something written about it. Cardiac emergency response plan is something that districts have referenced there in policy, and some language on physical examinations and screenings, which I will tell you is not athletic physicals. This is the type of things where people come in for vision testing and hearing testing and all that good stuff. That's what that's talking about, not athletic physicals. So now we flip to the administrative regulation, and what do we get? We get a lot of meat, right? We get the meat and the potatoes. We get those X's and O's. Medication. We said that the superintendent would develop regulations. Here are the regulations for how we're going to administer it. Here's how we're going to store it and monitor it. Here's how students can administer medications, all that stuff, right? We're going to give those specifics on that we said we were going to give. We give those in the AR. This is something that gets a lot of attention. There's a lot of dialogue about this topic. And so this might be a good model AR for you to take a peek at. Again, expanded information on seclusion and restraint. Wellness is a topic that under the Obama administration, there was a lot of talk about wellness and U.S. Department of Education nutrition guidelines. Many people would say rightfully so. This idea of the district having a wellness committee. Many of you in this pandemic have used the wellness committee to make decisions about pandemic restrictions and participation in athletics and all that good stuff. Wellness committee is something that should be existing even when the pandemic is, dare I say, over, or we've moved past it. Wellness committee is something that you still need to have and should have to address various wellness issues that are going to arise within the district. And this regulation is fairly prescriptive in terms of what you need to have. Again, the nuts and bolts, the X's and O's on EpiPens. And as I mentioned before, if you were to do something on opioid antagonists, this is maybe a category where you'd want to put it here as well, but administration, reporting, et cetera, et cetera. And again, some X's and O's on our cardiac emergency response plan, which is something that every district needs to make sure it has. This gets into the AEDs, training of AEDs, having an emergency response team, all that good stuff. And so we've provided a lot of that X's and O's here. Some references on surveillance and sports concussions as well. And then DNR, do not resuscitate orders is something that's gotten a little bit of attention here recently. In essence, what we've been told by Lansing is that the district has to accept and honor DNR requests that come in. There was some back and forth about whether or not we needed to have a policy or maybe we just needed to have a regulation. We've given you some language here to reflect this new mandate from the state. Ultimately, we don't need to have a policy per se. We do think having it written down someplace makes sense, but there was a lot of talk because there was an effective date right around the beginning of April. And districts calling and asking if they needed to have a policy. You don't have to have a policy per se, but again, something written down somewhere. This is what we've come up with as a guideline. So I'm guessing most of you do not have something on this front. So this would be good model language to flag and something that might possibly be an addition to your AR manual, your administrative regulation manual, because it is new and these are new requirements from the state. Ultimately, at the end of the day, we have to honor and accept DNR orders. So we've given lots of language there about storage of them, training, all that other good stuff, what all these definitions and all of these phrases mean under this DNR heading. And so we sort of end on something that probably nobody has and things that you will need to address from at least an administrative regulation standpoint. DNR, do not resuscitate orders. Okay, that scrolls us through our student-focused policies. I'll pause again, and Anya, I'll put you on the spot again. Anything in the queue that requires larger group discussion?
I do have one question. Someone asked, for long-term suspensions, we currently send students to a disciplinary hearing with the board of directors. Is that practice still okay?
Um, Board of Directors, I'm assuming is synonymous with the Board of Education. And so it is somebody who has the authority to do something. So for give it to me one more time, longer term suspensions, right? More than 10 days?
Long-term suspensions, more than 10 days, yes.
Yeah. So ultimately, when we think about this idea of due process, somebody who's been designated, somebody who has the authority to put the student out or put the student back, has to have an opportunity. When we get into that longer term suspension, so more than 10 days, right? That's going to be on the heavier side of the line. Okay. That's where the more formal due process procedures are going to take place. That's why you would have a hearing, right? That's why there would be maybe this group of decision makers you referred to as the board of directors. Students going to be able to see witness statements. Students going to have a right to have an attorney. Student probably is going to come with mom and dad. Student might bring witnesses. I had a kid once who brought the local pastor. He brought his youth mentor from the church. He brought all kinds of different people. Brought the guy who worked for at the hardware store to testify to his personality and moral compass and all that good stuff. And so, yes, that happens in that more formal hearing. That is still okay. What's not okay, and your question doesn't necessarily contemplate this, but what is not okay is to simply say, we're going to put you out for 20 days. And that's it. And not do something more formal, not have a meeting with the board of directors or the board of education. There are still a smattering of districts. I had a district, a suburban Detroit district, that until a couple of years ago had language that said, we can put you out for 30 days. And they were never doing anything from a formal due process standpoint involving an opportunity for counsel, involving a hearing before the board. They were never doing anything. They were just putting kids out for 30 days. That was not cool. You could not do that legally. And I don't want to say the word illegal because I don't want to sell my client down the river, but not something that they should have been doing. And so we need to make that adjustment. And so if you're going to get north of that 10-day mark, you got to have that more formal hearing type environment because that's what GOS requires. That's a bigger deprivation of their property right. I will say, since the question got asked, Kevin, what about special education kids and what about manifestation determinations? Well, I've only been talking about from a due process standpoint, general education situations. That MDR, manifestation determination review, as it relates to our special education kids, they got to have, not only do they need to have, if we're trying to put a kid out for more than 10 days, not only do they got to get the formal hearing to have that happen from a due process standpoint, you got to finish your MDR before day 10. Because there are special education implications of removing a student from their placement for more than 10 days. That you have to do that manifestation first and figure out if the behavior is a manifestation of the student's disability or not. If it is a manifestation of their disability, you're not going to be moving to a disciplinary hearing. You're going to be putting the kid back at school, very likely, because their conduct is a manifestation of their disability. If it is not a manifestation of their disability, then you very likely will move into that due process hearing. I don't want to get overly confusing, but another nuance that comes up with special education students and general ed students is, okay, Kevin, well, do we add up the days, right? So if I have a kid that he's had a 5-day, a 3-day, and now we want to give him another 3-day, does that mean I'm over 10 days and I need to do this hearing and stuff? In the general education setting, no, the suspensions don't add up. In the special education setting, yes. So we could have 2 students, one general ed, one special ed. And in my 5-3-3 scenario for the general ed kid, we don't have to worry about being over 10 days because the actual suspensions are less than 10. For the special education kid, 5-3-3 puts us over a cumulative 10, and we've got to do an MDR. Not trying to confuse everybody, but that is a little bit of a nuance that is out there when you're talking about general education kids versus special education kids, and whether or not I need to do this formal due process hearing. For the general ed kids, it's only if that individual suspension would be more than 10 days, not a cumulative. For the special ed kids, the days, the suspensions add up. So one more confusing wrinkle there to throw into all of this equation. So before we said we were distinguishing between student-centered and now general policies, similar preamble in this section to the one we gave you before. And again, you say, well, Kevin, great. I mean, largely we're at the building, why do I need all these general policies? Well, because these general policies are one of those keys to alignment. organizationally, as a school district, what are the things that you are calling out in terms of behavior, in terms of conduct, in terms of things that happen in a building, and how might that benefit you to have it addressed organizationally and develop that interconnectedness, that cohesion across the board. And so acceptable use, we've all seen acceptable use policies. Everybody's got to behave when they're using our network and systems. I think this is something that's really, really important, something that we're seeing a rise, a prevalence in terms of the things that are happening in buildings. So some policy language there, and then obviously an acceptable use that gives pretty specific details about what we expect technology users to do and not do. We're thinking a lot about this in terms of student behavior. I will tell you that there's a lot of stuff that relates to adult behavior too. There are things that happen from a staff standpoint that they don't necessarily comply with this stuff all the time. And having these things out there from a policy, a board policy standpoint, and an administrative regulation standpoint can be really helpful in addressing some bad behavior by some of your colleagues. Maybe if you have staff members that aren't doing what they're supposed to be doing. And so you see, we're very, very detailed in terms of things that technology users should not be doing. And we've been intentionally vague in calling them technology users because it can be staff or student. This list gives us a lot of wiggle room to address behavior. And candidly, there is a lot of behavior these days that covers a whole bunch of issues. Policy statement on the ADA and section 504. This is obviously very, very important for the board to adopt. And I'm sure they've got a policy of some form that talks about the ADA in section 504. But if they don't, certainly something that they want to have. We like to use the policy as a place to identify who the school district's compliance officer is going to be from an ADA and 504 standpoint. We're seeing a prolific rise in 504 plans for students on a whole host of things on which students need accommodations. We have allergies, we have peanut allergies and other things. We see a rise in service animals, which is a topic I won't delve into today, but a lot of things that need to be addressed in a 504 plan. And so I want to make sure that from a policy standpoint, we have that topic covered. And then we've given very, very specific. And a lot of districts have been good about adopting a policy. What they aren't always great about is having a procedure that needs to follow that policy for what happens if somebody has a complaint. What happens if somebody thinks we haven't followed the ADA? What happens if someone thinks we haven't followed 504? What is the procedure in place to address a concern if somebody comes forth and files that complaint? And so we've given that to you here. And again, if you're in the building, you might say, that's great. I'm not really going to worry about a 504 procedure, but this is a great opportunity. This is a great opportunity to ask the people who maybe are worried about it, do we have it? Is it something that we should implement? Is our procedure consistent with this? And do we have consistency across the board in terms of our expectations? So a good opportunity to use the good old legal survival guide as that resource and look at what we've got here to try to get that alignment. And so I won't go through all the steps, but we certainly have it there. Web accessibility, a huge issue that came up a couple years ago. Many of you might be aware of the fact that there was an advocate, who shall remain nameless, who filed hundreds of web accessibility complaints all over the country, including a great number of them here in Michigan, claiming that the district's website was not accessible to those with various disabilities. Believe it or not, there are rules on those things. The U.S. Department of Education Office for Civil Rights got involved. It talked about standards for school districts, asked districts to change things, so on and so forth, identify a web accessibility coordinator who would periodically go through and check and make sure that everything was accessible. And what are we talking about? We're talking about individuals with vision disabilities, mobility disabilities, so on and so forth. And is the information on your website available to them? It's not a bad concept to look into. I think we probably didn't need the hundreds and hundreds of complaints that we got, but it brought awareness to the topic, and OCR was very aggressive in working with districts. Why is this important to you? There might be parameters that you need to follow if you're developing content. Maybe you're maintaining the site for your building. Are there requirements that you have with your tech people in terms of how you're supposed to be adopting content? Are we supposed to be doing certain things with PDFs? Are there videos? Is there closed captioning that we need to have? What about the board meetings that we post? all that good stuff could very well fall under web accessibility. We've encouraged our clients and our policy clients specifically to adopt web accessibility policies and related regulations, which give the X's and O's of how we're going to do this. So if we get a complaint from somebody, if there is a concern, and not just because there's a complaint, we might legitimately have somebody who has a mobility or a vision disability or a hearing disability trying to access our content, and we want them to be able to access our content, giving you all of this material. So this might be another good one to flag and say, hey, do we have this? Is this something that we need to look at? We talk about auditing the website, training, addressing accessibility concerns, how people can file complaints if they have concerns, so on and so forth. I will tell you, this issue is still bubbling. I had 2 emails in my inbox last night from the U.S. Department of Education Office for Civil Rights, various investigators who are responsible for monitoring compliance. And they flagged a couple of our school districts and said, hey, they've got a couple of pages that don't look like they're accessible. Can you guys go ahead and address this? And so it's still out there, something to think about. Bloodborne pathogens, a policy that every district has to adopt. So we've given some model policy language there. Again, blue board policy. Same with communicable diseases, which much like immunizations 18 months ago, we didn't worry too much about the communicable diseases policy. Now something that everybody is looking at and going to. We've still kept our policy statement from a board standpoint pretty Spartan and to the point, simply inserting the county health department and then largely following what the county health department is telling us to do, and or what the Michigan Public Health Code is telling us to do with respect to communicable diseases, recognizing, of course, we're under the jurisdiction of the DHHS as they issue epidemic orders, so on and so forth. The meat and potatoes on this, again, in the AR, breaking down into various categories of communicable diseases known not to be spread by casual contact compared to those that are spread by casual contact, so on and so forth. Anya can probably talk more about this tomorrow. I know you all have developed forms about giving notice to families about cases and close quarantine contact and all that good stuff, things that we've developed over the course of the last 14 months that we never thought about or had to worry about previously, but things that we have to think about now and probably will have to think about for the foreseeable future. Copyrighted works, believe it or not, there is a Copyright Act of 1976 that says we can't be copying books and making our own copies and all that good stuff. We don't often think about it, but I will tell you it comes up. I just got a claim from an author the other day who claimed that one of our high school coaches had retweeted his intellectual property, his copyrighted protected quote, and they were prepared to file a copyright infringement claim. And so these things happen. So having awareness from a board policy standpoint about our responsibility to adhere to the Copyright Act of 1976 is important. Giving teachers some administrative guidance under the burnt orange here on, single copying, multiple copying. These are all good things. I know it sounds mundane, guys. I get it. It's sleep inducing, but at the same time, good stuff for us to have a resource so people know what they can and can't do from a copying standpoint and a copyright standpoint. 4.7 here is the big enchilada. And I alluded to this earlier. And I'm looking at the clock. We've got about 28 minutes left. I want to make sure that I leave time if there are questions, or if you guys just want to fire random stuff at me, that's fine. But I cannot emphasize enough. I talked before about criminal sexual conduct. I talked before about Title IX. I'm going to kind of wrap all of that into this big ball of discrimination and harassment. If there is an area, and I'm going to say it again, if there is an area of vulnerability right now for school districts, if there is an area where there is tremendous societal awareness, if there is an area where there is tremendous societal push for accountability and otherwise, this is it. And yes, discrimination and harassment on all different categories, right? Racial discrimination, national origin discrimination, all of it. It's all bad, it's all prohibited. But sex discrimination and sex harassment in particular is the lightning rod. It is the number one issue. It is what we are dealing with extensively on a daily basis, with calls from districts, with calls from buildings on how to address it. I told you before, this again, blue board policy language. We do prohibit generally discrimination on the basis of sex. I'm not saying you need to go in and amend the policies that are adopted by the board. and specifically include gender identity, gender expression, transgender status, sexual orientation. People have interpreted all of those things to fit into the definition of sex on the basis of sex. And so you don't necessarily need to change the policy, but we need to think about sex having a very broad definition, right? There's a lot of things that are in there, but we got to think about having a broad definition, being inclusive of gender identity, gender expression, transgender status, sexual orientation, and the way we respond to situation. Okay. And so from a policy standpoint, short, sweet, and to the point. Okay. From an administrative regulation standpoint, what are we looking at when we have allegations or concerns of discrimination or harassment, and how do we address them? And so what we've given you here, and it's about 17 pages, there's a lot of information here. How do we address from a process standpoint? Yes, we're going to have somebody who's the compliance officer, the Title IX coordinator. We've broken this out: discrimination and harassment when it involves students. So very, very detailed in terms of what are the terms that we're using? What is the procedure that we're using? Step 1, step 2, step 3, informally. What if there's a formal complaint? Step 1, step 2, step 3, so on and so forth. Step 4, how do we file a complaint with the Office for Civil Rights? How do we maintain records? All that for students. Then we give you the next one: discrimination, harassment when it involves employees. And we give you all of this granular detail on what to do and the process as it relates to employees if there's claims of discrimination and harassment. But wait, there's more. We've given you very specifically students and employees when it relates to both of them, and how do we navigate this stuff, okay? And you'll see, as I'm scrolling through, you probably see Title IX, Title IX, Title IX, time and again. Our duty to respond, our duty to address complaints, our duty to provide supportive measures to students that are complaining or have concerns, formal complaint, what does it look like, whether we can have informal resolution, what an investigation looks like, so on and so forth. There is a lot of content here to digest, okay? And so I know I just scrolled through, I don't know, 10, 15 pages very, very quickly. What I want to tell you about this topic is this. There are new regulations for Title IX. It took the Trump administration, again, not a political commentary, it took the Trump administration 4 years to go through the rulemaking process to adopt new regulations that relate to Title IX. Kevin, you keep saying Title IX. What is Title IX? Title IX prohibits discrimination on the basis of sex in any education program or activity. In essence, it is the federal government telling us we want a school educational environment that is free of discrimination on the basis of sex. Okay? And once upon a time in 1972, when Title IX was adopted, the lens through which we examined Title IX had a lot to do with sports, right? Why is it you got 25 boys varsity sports and only 2 girls varsity sports? That doesn't seem right. We need more equity in that. If we, the federal government, are going to give you, the school district, money, you better use that money equally for both sexes, right? And we saw a lot of boys programs going away, girls programs getting added. We saw realignment of seasons, all that good stuff, right? That was kind of how we focused on Title IX for a really long time. What Title IX was always intended to prohibit, though, was traditional sex discrimination, sex harassment. And what we've seen in the more modern context is a focus on sexual violence, true sexual harassment, LGBTQ students and student rights, and addressing bad behaviors that unfortunately go on that are connected or have a causal connection to the school environment. And so right now, there is absolutely a heightened sense of trying to address that behavior. The new regulations, which were issued by the US Department of Education, went through, again, an extensive rulemaking process, and they were trying to formalize how educational entities, K-12 and universities, handle these Title IX situations. They were trying, frankly, to address the myriad examples of gross non-compliance that were happening all over the country. And I hate to say it, you see my Spartan helmets there in the background, maybe no situations more glaring or heinous than what went on or didn't go on in East Lansing in terms of how they were responding to Title IX concerns. I don't want to say brushed under the rug, but frankly, issue of non-compliance, situations not being addressed in a proactive, coordinated, meaningful way. And so what the US Department of Education sees is a bunch of school districts and colleges not taking Title IX really seriously. And they drafted 2,300 pages of regulations to make sure that we do take them seriously. And there's a lot of prescription in the procedures we're supposed to follow. Those new regulations took effect last August, so just about the beginning of this school year. Now, one more dynamic, political season, presidential election, change in administration. Different administrations have different priorities, particularly when they change political party. And so we've already seen President Biden and his administration signal that they're going to go back and look at these Title IX regulations, and they're going to probably try to make some adjustments to them. Why, Kevin? It took 4 years for them to pass them. Why do they want to make adjustments? There is a belief that the new regulations are too favorable to the respondent, is what we now call the alleged perpetrator, okay? There is a belief that the new regulations are anti-victim, that they are pro-perpetrator. I'm not here to offer a commentary on that one way or another, but I will tell you that is the dialogue that is out there. And so why I'm telling you all this is that we as a school district find ourselves in a really precarious position. There's tremendous societal awareness about issues of sexual harassment and Title IX specifically, particularly here in Michigan, in large part because of everything that happened in East Lansing. There's great awareness, there's great push, there's a lot of sensitivity and focus on the topic. We've got these new regulations, which are very prescriptive, difficult to implement. I mean, we do trainings on Title IX regulations that are hours long. They're difficult to implement. There's a lot of process that needs to be followed. A lot of, I don't want to say hoops you have to jump through because that has a negative connotation, but a lot of boxes you have to check to make sure you're doing what you're supposed to be doing. Introduced to that, a new administration that has signaled they don't like the new regulations and are intent on changing them. What are we supposed to do? So before I talked about, and obviously I've given you lots of pages of process and steps and all this good stuff. That's all great content. These are issues that you need to have that little voice in your head. You need to ask your Title IX coordinator. Every district has one. If you don't know who it is, we need to fix that. Everybody needs to know who the Title IX coordinator is. The Title IX coordinator needs to get coached up. You need to have an awareness of the processes, the protocols. There are certain letters and forms that need to be sent by the Title IX coordinator to make sure that he or she is doing everything that is required by these new regulations. And so if I'm going to give you a walkaway, and hopefully there's a few walkaways that you could take from our time this morning, we talked about a few of them along the way. Title IX and making sure that we're doing what we're supposed to be doing might be the single greatest takeaway I can give you. And using these resources that are in the guide from an administrative regulation standpoint, from a policy standpoint, and from a code standpoint to get ourselves lined up. If you say Title IX new regulations and you see like a question mark over the person's head that you're talking to, this is a great opportunity to seize it, to seize the opportunity and try to get us in compliance. Because if we do not have awareness organizationally, if we do not have the protocols in place, and if we do not have a crystal clear vision of how we're going to move forward on these issues, we are going to get burned. And I don't want to be alarmist, and I hate being like Debbie Downer talking about this stuff, but I will tell you on a day-to-day basis, it is, I don't want to say it's the only thing I'm dealing with. It is the majority of what I'm dealing with, and districts are getting caught flat-footed. And so, yes, that is Kevin sounding the alarm bell. That is Kevin trying to bring urgency to this topic. Check in and see where you are at. First call should be to Title IX coordinator. And if they need these resources, you can say, hey, guess what? I got this great guide. It's got them in there. And you can provide those to the Title IX coordinator to get you aligned. As situations arise in the building that might look like they're sexual harassment, they might look like it's issues based on sex, you at least need to have the conversation with the Title IX coordinator and say, hey, look, is this Title IX? Do we need to be worried about that? Because that's going to take you off in a whole different process. It's not just going to be doing your quick down and dirty investigation and issuing a discipline under the student code. If we have Title IX implications, we're going to have to deal with that first before we get to the student code violations. So again, I know a lot of information. We do trainings that are hours long on Title IX. I just want to sound that alarm bell a little bit and make sure that you're aware of that and make sure that you can address that with your staff. Social Security numbers, policy, most boards already have it, but a good thing to look at. Huge one that we get, lots of stuff on digital communications. If you're dealing with students who aren't doing what they're supposed to be doing, if you're dealing with teachers who aren't doing what they're supposed to be doing because they're at home and they drink a bottle of Pinot Grigio and get on their blog and start saying stuff, digital communications very well may be the policy and the administrative regulation you need to be looking at and you need to be leaning on. A lot of districts are grappling right now with how to address social media behavior by staff and students. this is a great starting point. And so use this resource, blue for policy, orange, burnt orange for our administrative regulation. It gives us the teeth that we need to address bad behavior, both by staff and students when they're online doing things they shouldn't be doing. So you can use this as a baseline to create those expectations and set those standards. Freedom of Information Act, there's always little interesting tweaks to FOIA. We've got a really nice, robust policy here and related regulation for the board to address and for our administration to implement. Actually, it looks like we got most of it in policy now, which is a pretty long policy. That gives you everything you need to know in terms of the process of processing FOIA, is getting the good faith deposit, timelines, and all that good stuff. So if you're involved in FOIAs at all, great to know what you can and can't do. And we've given this here. We've given this as a policy. I guess we have. I probably would make the argument for being an administrative regulation, but we don't need to have that argument here. But it's good to know that it's there, and good to know that you can access it. That gets us, I think, to the end of our general policies, and exactly as I planned it. 15 minutes left to take everything off the screen, put myself back on camera, and say, we got 15 minutes. What do you want to talk about? You can use that Q&A tab to fire any questions that you might have about anything that we've covered in the 3 sections that we've looked at. Or if you're like, Kevin, this is my one chance to ask you a scenario, I want to throw you a scenario, fire away. This is what the time is for. This is why it's here. I know everybody's got a lot of stuff they got to do, but we've got 15 more minutes allotted, and I'm happy to use every bit of it to answer any questions that you might have. Or you can save them all for Anya tomorrow too. That would be fine. But Anya, what do we got? Anything in the queue that we need to address?
Sorry about that. No, nothing in the Q&A right now. All questions have so far been answered.
Wow, awesome. Well, I feel like I should, tell a story or sing a song or something, but I won't do it. I know how valuable everybody's time is, and so I won't belabor it. I won't belabor the point if I don't need to. But what I would say is this: remember what we talked about at the outset in terms of using. I've overused the word resource, but using this as a resource and using it as an opportunity to help align what's going on with the various stakeholders across district. Great opportunity to initiate a conversation with the board or the board policy committee, with the superintendent, with those who are charged with drafting the code and or the administrative regulations, and seize the opportunity to get that stuff lined up. That's ultimately what we want to do. If we are cohesive, if we are in line, if we have all of these resources in place, it puts us in a much better position to be able to address overall district operations and not just the one things that are happening in our silo. See a question? Is this? Yeah, go ahead.
Any suggestions, commentary on how to deal with staff members that wear political clothing in the presence of students?
Yes, political clothing. Well, guidance or commentary. I certainly, if our standards are articulated from a dress code standpoint, that would be applying both to staff and students. That's one thing. Sometimes there's language in we have teacher handbooks or student handbooks, things like that, that can address that behavior. That's there as a resource. I think, there's this fine line between what can we do and what should we do. And depending on what it is, if it's really brazen, that might be one thing, but let's just say something that's a little bit more subtle, okay? There's always this debate about what is First Amendment protected versus what is appropriate for the school environment. So I always get the question when it comes in is, can we discipline this person? Can we fire them? Can we send them home? Can we suspend them? Can we this? Can we that? Can we? And sometimes the answer is yes, sometimes the answer is no. It depends. I hate to say it depends on the clothing. I hate to say it depends on the message, but largely these are case-by-case scenarios. There is a difference of somebody wearing a polo shirt that says very small Trump 2020 versus somebody wearing a Confederate flag. Those are different things from my perspective, and I think they need to be responded to differently. I think very often it's not a can, it's a should. And what we should probably do is use those opportunities to counsel our staff members, talk to them about what their role as a teacher is, what messages that they are sending, and I don't mean the substance of the message, but what type of message it sends, why it might pose a challenge, why they might be putting themselves in a difficult predicament. Because if they're wearing political clothing, we know anymore, if you're wearing an article of political clothing, 50% of the people will like it, 50% of the people will hate it, that could create issues with students. It could create issues certainly with parents that will make the teacher's life more difficult than it probably needs to be. And so, I like to think about, can we, maybe depending on what it is, we might be able to discipline, we might be able to address, there might be a First Amendment issue there potentially, maybe not. But I think more often than not, it's a should we, and using the opportunity, we'll call it a growth opportunity for our teachers. To counsel them, to talk to them and make them see the big picture. If they're adamant and say, well, I really appreciate everything you said, but I'm going to wear my Trump 2024 t-shirt to school every day. Well, okay. Now maybe it's a little bit of a different discussion and we get into the can we, and can we address it? I would say, again, talking from a 50,000 foot perspective, do we have the ability to address political clothing on a teacher during the school day? Yes. I could probably make the argument that it's going to be disruptive, particularly given the current political landscape, and that we probably can. Again, that's a 50,000 foot answer, but I probably would want to have a conversation about the specific circumstances. And I would like to try counseling the teacher first before we go there. But probably from a big picture perspective, it very likely is something we can address. But let's talk about it first.
All right, Kevin, what are your thoughts on having a handbook in a digital format with digital signatures and having hard copies for those without access versus just providing all hard copies and collecting physical signatures?
Yeah, I think it's awesome. The technology is there. We can do it. It makes record keeping easier. It makes we save trees, which is important. And so I've got no problem with that. I know a number of districts have moved that way. I think the key to what you just said is so vital, because we know that very often, and we've learned this in the last 14 months, there are some access and in turn equity issues when we only have things online. Is having hard copies available, messaging that appropriately. I know I've had some people say, well, isn't the concern that, it says parent sign off and the student's the one who signs off because he just clicks the button, yada, yada, yada. Sure. I mean, those are things, but I think we need to make it really clear in our message of what our expectation is. And if somebody wants to be nefarious and click a button when they're not supposed to, that's on them, not on us. But I think providing those resources in digital format, as long as we have a hard copy option for those that maybe can't access it, I think is a great way to do it. And it's more efficient environmentally and administratively. And those are always wins in my book. So I'm cool with that.
All right. Any thoughts on the current Supreme Court case regarding students' online speech and its impact on school policy? And I'd be happy to talk about this one too, if you'd like.
Oh, yes. Do I have thoughts? So I'm gonna keep an eye on the clock because I don't want to go too far afield. It's really interesting because there was a case that we thought was going to go to the Supreme Court a couple of years ago called Bell versus Itawamba County Schools. And this was a kid that had written a rap song that, depending on your perspective, threatened violence against some school teachers. Who the rapper's position was that the teachers had committed sex harassment against some female students, and he was calling them out. Some movement in between the courts, district court, circuit court, a re-review by the circuit court. Ultimately, they found that it was within the purview of the district to discipline this online off-campus conduct. So ultimately, the outcome at the circuit court level, U.S. Circuit Court level, was a pro-district decision. And they had some very strong language in there about the fact that, we as a judicial establishment are still looking back at the Tinker case from 1969. Many of you might remember Tinker as the black armbands, the substantial disruption of the school environment, all that good stuff. And we're still using a Tinker analysis on this stuff. There's nothing modern about what we're looking at. They certainly weren't talking about Facebook, Snapchat, or the internet back when they were talking about black armbands. But we're still using Tinker as our baseline. So we really thought Bell was going to be the case that got up to the Supreme Court, and it had come out as a very pro-school decision. And we thought, great one to go up and confirm that we can in fact discipline this online off-campus conduct. The Supreme Court didn't take that case. And instead, a couple years later, they've now taken this case, which I'm not mistaken, emanates from the Third Circuit. And the Third Circuit, Fifth Circuit's down south, Texas, Mississippi, Alabama. Third Circuit, East Coast, a little more liberal. There's different political views on this. And the Third Circuit has generally been somewhat antagonistic towards school districts as it relates to online content. They are the circuit that a few years back, there were students making fake profile pages of administrators. Remember MySpace? There was fake MySpace pages and some other stuff. And the circuit basically came out and said, we don't think this is a big deal. Administrators need to get tougher skin. This doesn't really have a connection to the school environment. It's off campus, et cetera, et cetera. Of course, school districts hated those decisions because they were not pro school district. They were pro student and were allowing students basically to misbehave online. But those Third Circuit decisions kind of historically stood as outliers. And now we've got this Third Circuit decision, which was a pro-student decision, not a favorable school district decision, and it's up at the Supreme Court. And so we're really hoping that it gets addressed, and they reverse what the Third Circuit has done, and they come up with a pro-school district standpoint. From a purely legal standpoint, from a purely legal perspective, it'll be nice to get something. I hope they give us something, because candidly, trying to assess what a kid is doing on Twitter at 2 o'clock in the morning from the comfort of his bedroom when he wants a snow day is really hard to analogize to student protesters wearing black armbands in the mid-'60s. I mean, can we make the intellectual jump? We can, but it's really hard it's not really an apples to apples comparison. The instantaneous nature of online conduct, the breadth that it can be accessed by, not just people in the school, but the whole world can see it. And these messages spread like wildfire, as we know. So excited to get something from the Supreme Court. We have a conservative Supreme Court overall. And so I'm inclined to think, to your question, I'm inclined to think that they would come up with a analysis that was very pro-school district, that would recognize our ability and the impact, our ability to discipline and the impact on the school environment, the very substantial disruption that is caused to our environment by this conduct. And they would deviate from this sort of more liberal, very pro-student perspective that the Third Circuit has had. One thing I've learned about is I don't handicap Supreme Court decisions, because you never know what you're going to get. But I would think, given the composition of our court and their general sort of deference to schools, and the fact that I do think that we can very logically show a connection between the school environment and what's happening with off-campus online conduct, I'm hopeful that it'll be a pro-district decision. And we're excited to have something that is a little more current and culturally relevant than black armbands on student protesters. So kind of a long-winded answer, but that's what I think.
I did want to, if I could make one comment about another recent Supreme Court case where a student, and Kevin, this goes in directly to everything you were just saying, where a student, I believe, I'm not 100% sure on the facts, but what I understand is that she possibly did not make the JV cheerleading team, and ended up posting on Twitter some variant of F cheer and F the school and F, and so that was recently heard by the Supreme Court. Oral arguments recently heard by the Supreme Court. And again, I'm thrilled, like you were saying, that we possibly will have another very modern Twitter related interpretation of the Tinker standards.
Yeah, it's time. It's definitely time. That's for sure. That's for sure. I don't see any other questions in the queue. I do see that I got a note here from our tech people who said that, yes, they're going to be sharing the recording. So we were telling the truth when we said that. I always love it when a plan comes together. And here we are at 10:58. We promised you till 11. And so we're on time. Appreciate everybody attending. Remember, join us tomorrow. We're not done, but wait, there's more. Join us tomorrow at 9 o'clock again. Anya is going to lead us through really, really important stuff, annual notifications and forms, which has awesome practical effect. And then we're going to do some scenario work, which I think will be really, really beneficial. So you can see how all this applies. What does this all look like in the real world? So another couple of awesome hours tomorrow. Appreciate everybody's attention. Again, thank you to MASSP for their partnership and their support with this project, and to our MJ Tech team. I want to give you guys a public shout out. You guys do awesome work. We appreciate you making this look seamless and hopefully making us look good from a tech standpoint. So thanks, everybody. Have a great afternoon, and we'll see you back here tomorrow at 9 a.m. Thanks so much. Take care.